Hi folks, and welcome back to Conveyancing. This is video 4 in the video series on seller disclosure. And if you think back to video 1, we had a look at disclosure obligations at law, particularly defects in title. Then for videos 2 and 3, we had a look at the seller's obligations to disclose under statute. And weren't there just a few of those? And today, in this last video, we will have a look at the seller's disclosure obligations under the REIQ standard terms and conditions. So let's jump in now. Now, it certainly makes most sense to have covered these things the way that we have, because it's really only with an appreciation of both the kind of messy situation at common law and the wealth of statutory law that we can work out exactly what the REIQ has done in this area and how much it has helped tidy things up, so to speak. The main two issues that we need to get across in terms of the REIQ contracts are seller's warranties, and that's a bit of a misnomer because they're kind of more like conditions, and property adversely affected. Now, having done video 1, where we talked about defects in title and defects in quality of title, I'm not sure you'd pick it up from the text, but the seller's warranties provisions in the REIQ standard forms kind of marry up more with the law that we learned around defects in the title itself, and the property adversely affected provisions in the REIQ contract tie up more with defects in quality of title that we looked at common law. So just bear those two distinctions in mind, and we'll jump in and have a look at the seller's warranties. Now, I've cut and pasted these things here, but I think I'll take you to the live version of the contract because it's a bit more exciting. So we'll just go to that now. So here we are at the REIQ standard form contract for houses and residential land. I'm sure that you'll give advice on a few of these in your career. Let's go down. This is all the schedule that the real estate agent and the buyer and seller will complete. Special conditions there, normally you'll just put C attached and you'll draft up your special conditions. We'll get to special conditions in week 9. Your definitions are all here up front as per usual, and we'll just flip down to here we are. Matters affecting the property. Clause 7 is where we're at for today. And as I said, 7.4 seller's warranties, more like a misnomer because they equate to conditions. You'll see that if there's a breach of either 741 or 742, the buyer may terminate the contract by notice to the seller. So clearly these are conditions and not warranties in the technical sense that we would use them as lawyers when we're talking about contract terms. Okay, so the first one that you can see there is that the seller warrants that, except as disclosed in this contract, at settlement. Notice, at settlement. So you're warranting that, other than you've actually told the buyer there's something else happening here, as at the date of settlement, sub A, if the land is freehold, it'll be the registered owner of an estate in fee simple in the land and will own the rest of the property. This is your most fundamental obligation to deliver as the seller. You've got to give the purchaser freehold in the estate that they're purchasing. Obviously, as I said, this is the flavour of these warranties in 7.4. They go to title, okay, really super fundamental stuff that the buyer must be absolutely guaranteed of. So as it's settlement, the seller is saying they will be the registered owner of both the fee simple in the land as well as owning the rest of the property. Now, if you shoot up to the definitions section, you will see that property means the land, the improvements, and the included chattels. Okay, the seller has to be the owner of the land and the land improvements chattels. Now that kind of clause isn't going to be a problem in 99% of the cases. The text does go through a case, Rolls and Radford, where two sellers jointly were disposing of property to the incoming purchaser, and unfortunately for the sellers, they decided to transfer the lot from both of the sellers into one of the sellers' names prior to settlement. And the purchaser found out and decided to back out on the basis that 7.41A had been breached, and it had, literally, because they hadn't disclosed the fact that they were always intending to transfer the lot into just the one seller's name. And so as contracted, that both of the sellers were on title, but at settlement, the people that had contracted to sell the property were not the registered owners of the estate in fee simple. It was just one of the sellers at that point that was the registered owner of the fee simple, and the court construed the term very strictly. The buyer could back out on the basis that that clause had been breached. So it's something to bear in mind, obviously, if you're developing or going to flick on part of a property. You're going to do some transferring from one name into another name or other fancy footwork between the date of contract and settlement. That is a clause to watch out for. The second one relates to leasehold, kind of similar provision there. No real rocket science to that one. The third one relates to capacity. So if you think back to your contract days, all the way back to the very, very beginning, you would have covered capacity and particularly the ability of minors to contract validly. Minors being persons that have not yet attained majority or the age of 18 years. Minors can hold land in Queensland and dispose of it. But the tricky thing is, if you do recall back to your contract days, that minors are able to disclaim or repudiate a contract within a reasonable time of attaining their majority. So if you are, as a purchaser, contracting with a minor, there always is this kind of latent fear that once the contract's gone through, if the minor then reaches their majority of age and thinks, maybe I shouldn't have sold that land after all, scratches their head and thinks, I'll just have that contract set aside now. Well, we have the case of the aptly titled case of Percy and Youngman, and in that particular situation, once the seller had actually sold and had second thoughts, the issue for the buyer was that the buyer had already registered on title. So even though the seller was attempting to disclaim that contract within a reasonable time of attaining their majority, the court said no. Once things are done and dusted and the incoming purchaser has been registered on title, it's not appropriate to allow a minor that has just attained their majority to disclaim that contract. So if a buyer did find out that their seller was a minor once they had executed the contract, then obviously 741 sub C will allow them to get out of that contract on the basis that the seller will not be able to complete at settlement if they won't have turned 18 by the time settlement rolls around. Of course, bankruptcy is the other main thing that you need to watch out for, and again, 741C will help you out there. The next two are kind of related. Sub D relates to unsatisfied judgments, orders or writs affecting the property. So in the olden days, we would say if there was a writ of execution affecting the property, nowadays they're called enforcement warrants. If there's one of those things floating around, obviously there will have been proceedings and judgment delivered in favour of one of the parties, and then that party has not yet performed, so there's an unsatisfied enforcement warrant out for something to do with the property, then in that case the seller that as a party to one of the REIQ contracts will have warranted that there is nothing out there in the form of an unsatisfied what we used to call writs of execution. So if we skip across to 7.4 sub 2, you'll see that it's quite a bit broader than 7.4 sub 1 sub D, in that you don't, as seller, just have to disclose everything that's happened after proceedings have been finished, so unsatisfied orders and writs of execution or enforcement warrants. But you also have to disclose everything that happens at the front end as well. So except as disclosed in this contract, the contract date and its settlement. So both when you sign the document of contract and also at settlement, there are no current or threatened claims, notices or proceedings that might lead to a judgment, order or writ affecting the property. So everything at the front end that's going wrong, if the seller's in disputes here that might lead ultimately to orders affecting the property, you need to disclose those. Now, if you recall back to our videos 2 and 3 on the statutory obligations of disclosure upon sellers, you'll remember back to the neighbourhood disputes legislation, and they were saying it's unclear really whether you would need to disclose fencing disputes under this particular clause of the REIQ standard form. At common law, it's not really something that you're going to have to disclose, is it? Because it's going to go more to quality of title rather than actual a defect in title itself. But under the REIQ contract, there's this question mark here. As I said, I'm not aware of any decisions that have clarified things yet, but the authors of the text say there could be two views here. Either 7.4 sub 2 should be restricted really to matters that would actually affect title to the property, because it's in this set of provisions that deals with very fundamental things that would affect title to the property. Or it may well be that the provision is construed more broadly, and even though neighbourhood disputes kind of proceedings in QCAT notices and so forth that are floating around about that kind of thing may well fall within 7.4 sub 2. So in an abundance of caution, I would say that the seller should disclose here, so that they're not going to leave the door open for the buyer to terminate under 7.4 sub 4 if they find out that there's any of these things floating around in the background there. So 7.4 sub 3 deals with environmental protection, and here you'll notice that what 7.4 sub 3 does is it actually widens out the disclosure obligations under the EPA. So you remember back to videos 2 and 3 where we were talking about the environmental protection legislation, and the regime there under section 408 requires a seller with land that's either on the relevant land register, like the contaminated land register, or is subject to one of the various notices, like a show cause notice or a clean-up notice or a site management plan notice, that they have to give the buyer a formal notice that the land is affected under section 408, and if not, the buyer can terminate under that provision. That situation is broadened out significantly. I guess it's in a similar way to section 7.4 sub 2 that we were just talking about, broadens out 7.4 sub 1 sub D about enforcement warrants. So similarly here about the EPA, not only do you have to go about disclosing under the EPA if there's any of these actual notices that have been issued or the land is actually on the register, but here you have to notify even if there are obligations to give the EPA notice of your notifiable activity on the land, or if there are any other circumstances that might lead to the land being classified as contaminated land. So you may not have had a show cause notice issued to you yet as seller. However, if there is something that is happening on that land or something that you're aware of that might lead to such things down the track, then this is the kind of thing that you need to disclose under 7.4 sub 3. Now, this is a self-contained little provision, so the termination provision is actually in 7.4 sub 3 itself. So you'll see there, if the seller breaches, the buyer may terminate by notice in writing given within 2 business days before settlement date, or they can complete the contract and claim compensation only if the buyer actually puts their hand up and says they want compensation before settlement date, obviously in writing. So that's 7.4 sub 3. 7.4 we've already covered off. That is the termination provision that links up with 7.4 subsections 1 and 2. And the seller, note sneaky little subprovision 5 here, the seller doesn't warrant that the present use is lawful, and that provision comes into play more when we're looking at property adversely affected. And we're up to 16 minutes now, so I'll end this video here, and the last little baby video will deal with property adversely affected. So I'll see you then, guys. Bye.